here. Not sure if you can see this, but I typed in the word Federal Civil Procedure Guide, and we're going to scroll down to it because a lot of people don't know about this guide. It's free to download, but it has a lot of pages of a lot of different laws. So I'm here to show everybody what they can use these laws for. I'm not an attorney. Sorry guys. Trying to do this again. So here I go back to the screen. So anyway, we're gonna go back to this Federal Rules of Civil Procedure. I'm hoping I can do this. So there's the site, and I do sell Legal Shield, but I'm not an attorney. But here this is. So here we go. We got. Let's see. This right here, okay? This is what about these judges, okay? These judges, we need to know this code of conduct. Let's click on it. Okay. So let's see my screen. But anyway, there's the code of conduct right there. And it says right there, effective March 12th, 2019. Okay? Let's click on that and see what it says. Okay, so this is the judicial canon that I'm trying to tell everybody about. Okay, canon 1. A judge should uphold the integrity and independence of the judiciary. Canon 2. A judge should avoid impropriety and the appearance of impropriety in all activities. Canon 3. A judge should perform the duties of the office fairly, impartially, and Canon 4. A judge may engage in extrajudicial activities that are consistent with the obligations of judicial office. A judge should refrain from political activity. Compliance with the code of conduct. Applicable date of compliance. Okay? So there's that. Tells you right there. Code of conduct for United States judges was initially adopted by the Judicial Conference on April 5th, 1973, and was known as the Code of Judicial Conduct for the United States. And these are all the changes they've made to this code. Okay? Okay, so it says right there. This code applies to United States Circuit Judges, District Judges, Court of International Trade Judges, Court of Federal Claims Judges, Bankruptcy Judges, Magistrate Judges. Certain provisions of this code apply to special masters. And how many of those do we have in the court system? And commissioners, as indicated in the compliance section. The Tax Court, Court of Appeals for Veterans Claims, and Court of Appeals for the Armed Forces have adopted this code. The Judicial Conference has authorized its Committee on Codes of Conduct to render advisory opinions about this code only when requested by a judge to whom this code applies. Requests for opinions and other questions concerning this code and its applicability should be addressed to the chair of the Committee on Codes of Conduct by email or as follows. This address, I've shared this address plenty of times before. So there's your first canon right there. I'm gonna see if I can get closer to the screen so you can see it. Now just take a look at that and see what it says. And I'm sharing this so that everybody has a chance to look at it. Know where to find it. Sorry, my husband's playing video games in the back. There's just so much here, right? Respect for law, and oftentimes they don't have respect for law. Outside influence. We know in a lot of other states, there's a lot of outside influence. There's just so many of them, so many of these canons, and we all need to be familiar with how to use them. It's not hard to use them. Hi, Lacey. You know, so a lot of these canons, the reason why I'm sharing them is because I want you to see what they look like, how to access them. Also, I want you to be able to compare them to what is on cot.net, which talks about all the illegal stuff that judges do, attorneys, U.S. attorney generals, all of it. Every single person that's involved in the court proceedings and what they do and how they do it behind our backs, and how you can compare it, so that way, you know, if you're a little more educated on this, you will like this right here, okay? Right here, this right here, who sees this? This right there. There's actually a code about ex parte communications, and really, people need to understand there's a code for this, okay? And it says right there, a judge may, let's go down to the screen, initiate, permit, or consider ex parte communications as authorized by law. When circumstances require, permit ex parte communication for scheduling, administrative, or emergency purposes, but only if the ex parte communication does not address substantive matters, and the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. There's just so much of it right there. With the consent of the parties. Confer separately with the parties and their counsel in an effort to mediate or settle pending matters. Judges don't do this. They should be doing it. And it's right there. It is right there that a judge can actually meet. It says right there, confer separately with the parties and their counsel in an effort to mediate or settle pending matters. And what do? They put us in mediation, right? With a mediator. But it says that they can mediate. It doesn't say mediator, it says mediate under the judge area, where it says right there, a judge may. So really, it doesn't mean, it means that we don't always need a mediator. So this right there. There's a bunch of this stuff right here that we can use, that everyone should be wanting to use in their case. Basis of merit. Okay, understand that word right there, merit. Okay. Sorry guys. Sorry. Trying to continue doing this. Let me see if I can put my because I don't want to silence the there. Hopefully everybody can still hear me. Okay. So hopefully everyone can still hear me. And since I'm going live, there's just so much of this that I want to share with y'all. And it says right there, disqualification, right? When they know they're biased, they should be able to disqualify themselves. They should be able to say that they are done with the case, that they're not going to solve this case, that they're not going to work on it. And if you look at the top, there's 20 pages. We're only on the 8th page. And this happens a lot, This happens a lot. Right there, okay? Like, for example, and we're going to use this example here. This one right here. In the Jennifer Probst case that, everyone kind of got mad at me about, saying I didn't help her enough. This right here, acting as a lawyer in the proceeding. I sent this stuff to her too. She could have used this in court, and she didn't use it. I hope someone else out there is listening to this live video and this part right here. There is no way an attorney can be a judge in your case if they already were an attorney in a previous case of yours. It's against the law. It's against the canons. That's why it's under disqualification. Okay? Because they already know enough about you to use that. To make a judgment call that they shouldn't be making because they know that much about you. So, if anyone out there has had a lawyer in their case who is now the judge in your case, recuse that judge. And push until you recuse that judge. Okay? Right there. It says, let's see. So what does it say? It says the degree of relationship is calculated according to the civil law system. Parent, child, grandparent, grandchild, great-grandparent, great-grandchild, sister, brother, aunt, uncle, niece, and nephew. This part right here, if everybody should be trying to look up fiduciary and what it means. Especially when it comes to the GALs. Like I said, this is just to help you understand what you can use. What you can use in your case, and then it says right there, remittal of disqualification. Instead of withdrawing from the proceeding, a judge disqualified by Canon 3C1 may accept, in the circumstances specifically set out in subsections A through E, disclose on the record the basis of disqualification. The judge may participate in the proceeding if, after that disclosure, the parties and their lawyers have an opportunity to confer outside the presence of the judge, all agree in writing or on the record that the judge should not be disqualified, and the judge is then willing to participate. The agreement should be incorporated in the record of the proceeding. And, that kind of should be thrown out, because what if you get a judge that doesn't want to disqualify themselves because they're afraid of being exposed? So they want to stay in the case just to keep it going. Like I said, there's just so much to learn with these canons. So important for everybody to know how to use them in all states, all 50 states, from Alaska all the way down to, Wyoming? This right there, it even says it right there. But I don't know if that's for CPS. Could be for something else. Right there though, there it is. There's that same stuff right there, right? There's that word, official capacity, right? And how many times have I said, sue them in their individual and official capacity? Because not only do they mentally know what they're doing, they officially know in their office what they should be doing as judges. They know it. So they can be sued. And see how it says, a judge may comment publicly on proceedings in which the judge is a litigant in a personal capacity, but not on mandamus proceedings when the judge is a litigant in an official capacity. That's why you sue in both, individual and official. And this is where you look up this federal RAPPP.21B. Type that into Google, see what comes up. That's how simple it is. Now, a lot of this, let's see. Okay. Just kind of showing everybody what this is. So, there's also law-related activities. This right here, this is another thing I want people to know about. Okay, organizations. The reason why the Supreme Court is so horrible right now for like the governor, Democratic governors doing what they're wanting to do in states that are Democratic states is because of this. Because a lot of the judges are running the Supreme Court. Okay? They're running the Supreme Court. And because there's judges running the Supreme Court and not like people or something, or like politicians that are not legally involved in nothing, they make judgment calls because they have judges running the Supreme Court. And it's so wrong because what these governors are doing to us is wrong. Businesses are closing down. There's just no money being made for any of these states that have these Democratic governors. And we really need to change that. We need to change the fact that judges can be managing the Supreme Court the way they are. And I know, just like I said, I'm sure this is out there for somebody. Someone's gonna learn something from this. This right here, okay? This actually goes in line with what I said earlier about individual and official capacity. So it says right here, while acting as a fiduciary, judge is subject to the same restrictions on financial activities that apply to the judge in a personal capacity. And that's why when you sue judges, you have to sue them in their individual and official capacity. Okay, there's, like I said, there's just so much here. Trying to go as slow as possible for everybody to get this. This right here, okay? This I think is so, this I think is so stupid because really, there is no pro bono legal services. You don't get them for long. That's why they have Title 4E funding for attorneys. And that's why I made a video about it. To show people in those specific states the contracts that I found that show there is no pro bono legal services. I mean, you'll get some somewhere, but they're still going to try to eventually charge you that $35, $25, or $45 fee. Okay? Because, they just don't do it. They don't do everything. The attorneys don't work for free. Okay. So here's the problem I have with this right here. We have a part-time judge who they don't want to hold accountable, and it says right here, is not required to comply with canons 4A4, 4A5, 4D2, 4E, 4F, or 4H3. And it's like, okay, what do you want? Why are they even a part-time judge if they can't comply with those canons? If they can't comply with all the canons, they shouldn't even be a judge. This right here. This is why our state legislators do what they want to do, and why the governor does what they want to do. Now look at this. They're not holding these accountable, and they're basically saying they can be special masters. So we basically have special masters running the legislative capitals of our states, because it says right there. I've looked into this before, and there's parts of it I still don't understand myself, but it's just special master. There should not be a special master. You know. And this is from, I think this was 2000, no, actually it says right there, it's effective March 12th, 2019. So from last year. So anyone that has a case, this applies to your case too. And that's the end of it. That's the end of it for this video. Thank you for watching, and I hope you share with more people. I hope this helps somebody out there understand what they're doing here in, the United States. I'm going to post one more video tonight, and I just hope you share it, and I hope you learn something from this video. Have a good night.